car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for joining us tonight. For the next half hour, we have a panel of experts ready to deal with the legal topic that we think is not only of interest to you, but is full of information, details that you need to know that may be helpful for you in the future. We'd love to have you be a part of the conversation. To do that, there are ways at the bottom of the screen you see you can take part in the conversation. And a neat thing that Hollis Wright makes available each and every Sunday night is an attorney standing by live right now to speak with you. If you'd rather to speak with someone live and chat with them, now's the time to do it. Take advantage of that opportunity all throughout the program this evening. Leading our conversation, he is the managing partner of Hollis Wright. Yep. Josh Wright, good to see you, sir. You good?
You too. Hope you had a great week.
I did. You?
You know, I feel like we start the show off that way every time.
But I generally do have good weeks, though. So
everything good in your life?
It's just, it's beautiful.
Better way to start the show.
Everything good.
All right, so, you know, we're going to be talking tonight about a topic we don't do all that often, but it's an important topic. 400,000 people per year are injured in premises liability claims. And basically a premises liability claim is a claim where someone's injured on someone else's property. Okay. And it can happen in a host of different ways. We're not just talking about falls and trips. We're talking about other injuries, things that happen on the premises. So we're going to be talking about that broad topic today. And we've got Josh Snable on the show. His law firm is the Snable Law Firm here in Birmingham. And, you know, we don't always do things that are within the sweet spot of Hollis Wright. So we bring experts on. Right. Josh is one of those guys. He's got a good first name, too, which I like a whole lot. So first of all, welcome. Glad to have you on.
Thank you, sir.
Look forward to kind of talking through this topic. How did you get into this area of the law?
Well, it's just one of those, like you said, it's just the vast majority of people who fall and get hurt. You know, if we're talking about premises liability, that's kind of an umbrella term. It's a term of art. Typically what you see is slip and fall cases. And that's where someone slips and falls, trips and falls on someone else's property. And really what you have to show in those cases is someone else liable for that injury, or is it simply someone else's own mistake, their own negligence, they call that.
And I'm assuming a lot of times people will come in, ask you to evaluate a case, and a lot of times you come back to them and say, you know, look, this is on you, this is not on someone else.
That is right. So the first thing you want to look at is, one, was there an injury? And two, was there what caused that injury? There's different statuses. There's did you come on to the property of someone for their benefit? Were you a social guest on someone else's property? So really you want to look at how someone is identified, or what status were they? Was there an injury that occurred? And then you want to see is someone liable for those injuries? So
let's kind of unpackage that just a little bit. So you've got different types of statuses someone can have legally. An invitee, a licensee, trespasser, all the things we learned in law school. But let's assume that you are going to a social gathering at someone's house, not for any economic benefit to them, but they invite you over. There's one standard associated with that type of injury versus if you go to a local retail shop and you're injured at a local retail shop or at a large retailer. There's a different standard associated with that. Is that fair?
That's fair enough. And what you're referring to is if you come onto the property of someone else for the benefit or the monetary benefit of the property owner, then you are coined an invitee of that business. As an invitee, the property owner owes you a reasonable standard of care. And that reasonableness is to be determined by a trier of fact, a judge or jury. But typically that reasonableness is to not have any sort of dangerous condition. If they are on notice of that dangerous condition, then they have the obligation to remedy it of that dangerous hazard, water on the floor, something sticking out in an aisleway. So that's reasonable in a standard of care. If you are a social guest, you're coined a licensee. And all that that property owner owes you is that to not commit any sort of reckless, wanton, willful act against you that may cause your injury, or if they're aware of some defect, that they remedy that defect. And I can go in more detail.
Yeah, so now when we talk about premises claims, and I know we talked primarily about the duties that are owed, it can apply to a lot of different things. For example, if you're aware that you've got a patron at your retail location that is causing injury to people, that can put you in a premises case, can it not?
That's
no
correct.
Different than a slip and fall or a fall at a Walmart, for example.
Right, right. And in particular, a nightclub owner. There are certain liabilities that apply just to nightclub owners, and that's called a Dram Shop Act, which it falls under the umbrella of premises liability, and that's where a club owner has a duty to not overserve its patrons, and if they do, then they are strictly liable. You don't have to show any sort of negligence on their part, that they knew or should have known that there was going to be some sort of injury occurring because of overserving that person.
All right, so I know we're getting ready to go to break, but Dave, when we come back, I want to talk a little bit about if you are on somebody else's premises and you're injured in some way, I want to talk a little bit about what steps you should take to make sure you protect yourself.
All right, we'll pick that up whenever we come back. As we head to break, a couple of reminders. We'd love to have you follow the firm on social media. Twitter, it's Hollis_Wright. Facebook, just search the term Hollis Wright and you'll find them right there on Facebook. We'd love to have you join us there as well. Stay tuned, more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Premises liability, our topic of conversation tonight. Ways you can join our program. You'll see at the bottom of the screen where you can get in touch with us. Also, a reminder, all throughout the program this evening, attorneys from Hollis Wright standing by live to speak with you. You know, the hardest ticket in this state each and every year to get, they're tickets to the Alabama-Auburn game. But fortunately...
You mean the Auburn-Alabama game?
The Auburn grad, Bama grad. You can see how that happens, right? All right, so ticket to that game. Fortunately, you guys at Hollis Wright going to help 4 folks out.
No question. So we did months ago iPad giveaways for people that went to the Hollis Wright Facebook page, liked the page, and then shared the post. We're doing a like and share again. And the concept is not just to build the volume of Facebook followers, it's to let people recognize and realize that we do a lot on social media on a weekly basis that may help them in their everyday life. And so we want people to have exposure to that. And so this is one way to encourage people to do that. And it's also a thank you and a give back to the community for the great 6 years we've had here on the television, and we've been honored to be in people's living rooms for a long time, and so this is just a thank you for that too. Yeah, great follow. Head to just search Hollis Wright on Facebook. You'll find them there. You just have to follow and then like and share that post about the ticket giveaway, and you'll be entered to win, so best of luck. All right, so back to the topic. Trespassers. Normally, trespassers have a negative connotation. Sometimes, however, it could be a small child, could be somebody that doesn't realize they're trespassing on a piece of property. Do some trespassers have rights? Right, so we've talked about licensees and invitees. Trespassers, normally, the blanket rule is they're on the
premises without any sort of invitation or else any legal rights to be there. But there is a caveat, and that's where you're talking about young children. And that's the doctrine of avoidance, and so, or attractive nuisance. And what you're looking at there is there's a couple cases out there. One's about an open well. And if you know that a dangerous condition exists on your property, you have an obligation as that property owner to prevent small children, as you said, from falling in a well. Also, swimming pools. You have to put a fence around your swimming pool so high. And that's to prevent some sort of tragic accident involving a child who may wander onto the property unknowingly.
So there are times when trespassers, even though it has a negative connotation, do have some rights.
Yeah.
You know, we see this actually a lot in hunting-related injuries, where an individual, you know, the properties where you hunt aren't always perfectly segmented off, where you know you're trespassing. You may actually be a quarter mile into somebody else's property with the expectation you're on someone else's property and that you're not a trespasser, and you get the cloak, if you will, of being a trespasser even though you didn't have knowledge of it. And so there are certain rights that still are there to protect you, to make sure you know, that you're protected in those circumstances. And I'd say this, if you find yourself in a premises event where you were injured, it's always good to get a lawyer involved because they'll know these categories.
Right.
And sometimes they may come back to you, as Josh and I have talked about, and say, hey, I'm sorry, but this is on you, right? This is not anybody else's fault but yours, based on what happened to you. But sometimes people are responsible for the injuries you sustain on their property.
A question we've got here for you guys. What if I'm injured on government property? Is there a special rule for those kinds of claims?
Yeah, actually, there is. The Federal Tort Claims Act, 1946, actually says that that there is a cause of action against the federal government if an injury is sustained on a federal land. So the best advice you can give is, if you're injured at all, consult an attorney. There's no charge, so to know if someone is liable for the injuries you sustain on their property.
So let's take kind of a typical example, whether it's a defective stair, whether it's produce or a product that's remained on the floor for a period of time that causes someone's injury, you know, a hip injury, for example. What do you recommend at the scene, after medical care is resolved, at the scene? What are some things you can do to help protect yourself to the extent that there may be a case there?
Right. So as you intimated, the first thing you need to do is, if you're hurt, seek medical care. But if you are able, you know, it's best to immediately report it to the property owner. And likely what they will do at that point is get an incident report. And that incident report will record the location of the injury, the date, the time, the responsible parties or who was involved, and always ask for a copy of that incident report. If you're able, again, you may want to note witnesses. If there's someone with you, of course, that's obvious, but record the names, phone numbers, addresses of any witnesses who could help corroborate your story. If you're able, again, we all have cameras on our phones. It's pretty easy to take pictures. Take pictures if you're able. Anything you think that could help establish your claim that someone else is liable.
Yeah. You know, the key to all this, and we talk about this in the context of other related accidents, whether it be automobile accidents or something else we've talked about here on the show, is documentation is helpful. I mean, ultimately what it comes down to is being able to have the evidence to support what happened is significant. And a lot of times in a premises context, of course, the premises owner is going to try and defend themselves, as we all expect they would, and their insurance carrier specifically is going to try and protect them. And if they can show that you contributed to your own injury, a lot of times you can be precluded in Alabama from recovery. So you want to be able to document everything you possibly can.
All right. We need to step aside. Take a break. As we do, a couple of reminders. We'd love to have you join our conversation. One more break to do so. Here's how you can get in touch with us. Stay tuned. We've got more of the attorneys coming right up.
I'm Carter Clay with the law firm of Hollis Wright. When someone whose unreasonable conduct causes an injury to someone else, the law says that person is negligent. So it seems the injured person should receive some type of damages, right? Not always so in Alabama. In tonight's Legal 411, we answer the question, what is contributory negligence and comparative fault? Alabama is one of only 4 states in the nation to withhold damages based on contributory negligence, meaning if you are at fault even just a little, you cannot be allowed any damages in a case. For example, in a case where a defendant may be 99% at fault for hurting you, if you are found to be 1% at fault, Alabama law says you get nothing. 4 states, Virginia, North Carolina, Maryland, and Alabama, plus the District of Columbia, are the only places in the country where a defendant can completely avoid paying if the injured person is even 1% at fault. This is very different from comparative fault, the measure used in 46 states. There are 2 versions of this system, but both essentially allow money damages based on the percentages. For example, if the injured person was 20% at fault for causing an accident, then the recovery for medical bills and wages is reduced by 20%. Numerous studies across the country show that people who live in comparative fault states believe this system of justice is more fair. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will always respond to every question you send in. That's our pledge and promise to you.
It's common for a potential client to ask, there are many great firms out there. What separates Hollis Wright from other law firms? My response is generally to talk about the strengths of our law firm in handling cases throughout Alabama and the United States. That we've recovered through verdicts and settlements, hundreds of millions of dollars for our clients. That we have financial resources to hire any required expert and to take their case all the way to trial, even if it costs us hundreds of thousands of dollars to do so. That we handle cases only on a contingency fee, which means we never ask the client to pay any costs of litigation whatsoever, and only recover those costs and a fee if we win for the client. That we have a staff of more than 20 employees that help us litigate cases from start to finish. That we've had a television show on NBC 13 for 6 years that answers thousands of questions to citizens for free each year. But what I've learned in the last 20 years as a trial lawyer is that clients want more and deserve more than all those things. Those things are expected of each law firm they consider. So with that wisdom, what I tell clients now is simply this. We are a family-oriented practice at Hollis Wright, just like their own family. That we are a team-oriented group that engages in team-building exercises and team-building events because it helps our clients win cases. That we are dads and moms and brothers and sisters. That we are former Alabama trial lawyer presidents. That our bedside manner is second to none. So what really separates our firm from others? We're balanced and well-rounded, and as such, we relate to people not just as lawyers, but as compassionate human beings. Human beings that know what it's like to face a day in court. We are advocates, we are compassionate, we are tireless. We are, simply put, Hollis Wright.
Welcome back into the attorneys in the final 10 minutes of the show tonight. So if you want to take advantage of that opportunity to speak with attorneys who are standing by live right now, you got about 10 minutes or so to take advantage of it. Josh?
Josh, when we went off, one of the things I wanted to talk about was stair-related injuries. There are certain code sections and standards that require stairs to be of certain heights, be in certain places, to have certain warnings. Do you see that kind of case a lot?
Sure. You know, stairs, I don't know if they're inherently dangerous, but they can be dangerous. And typically what you see is in the case of stair injuries is that involving a licensee. And as you'll remember, licensees are those social guests. So really you see stair injuries at the home that can result from buckled carpeting on the stair, missing planks in the stair, an uneven some sort of surface on the stair, missing handrails. So you as the property owner would have the duty then to remedy that defect or to warn that social guest of the potential hazard that exists.
How do these cases, from a contracting perspective, when you contract with someone, are these cases generally taken on a contingency fee basis?
They are. They're always taken on contingency fee basis, which, and like I mentioned at the beginning, it's always free to at least talk about your case, and it's free to prosecute that case if there is a liable party.
Yeah, you know, it's one of the nice things about being a lawyer on this side. I think the contingency fee case situation for a plaintiff is that they get the ability to have competent counsel that will fund expenses to investigate their claim, whether it's a car or truck accident, whether it's a premises liability claim, whether it's a wrongful death case, whatever it may be. There's competent counsel out there that has the ability to prosecute a claim and give you the same level of service and the same level of representation that you would get on the defense side of the bar, on the corporate side of things with a contingency fee contract. So I'm a big proponent of it. I think it's good for folks not to have to come out of pocket to litigate cases, and the lawyers shoulder the responsibility in those cases.
Right. Our show is the Joshes tonight. We have Josh Wright, Josh Snable. It's hard even for me to mess this up. A question for you guys, and Josh Snable, will go to you with this one. I heard you say leased the property, that term. Can the tenant of an apartment building be liable for an injury?
Sure. Well, maybe.
Right.
The tenant is control of the premises. So really you see these type cases where, let's say the tenant owns a dog, and that dog is an inherently dangerous breed of dog, a pit bull.
Poodle, pit bull, yeah.
Pit bull, poodle. But that dog has bitten someone in the past. Not only could the tenant be responsible, but if the owner of those premises knew that dog was there and had bitten someone in the past, right, that liability could be impugned over to the owner of the property as well.
Okay.
Give it. I know you probably got another question, but give us, walk me through this. I'm sitting at your conference room table. My mother, who's 85 years old, has now fallen at a local store called a convenience store, and there was something on the floor, and she broke her hip. She's got to have surgery. She didn't know it was there. How do you walk through kind of that evaluation? What are you trying to do as a lawyer to gather information to assess whether or not that's a viable claim or not?
Number one, get her well. That's always the number one concern. Number two, if there's an incident report there, you want to make sure that some third party, what caused that hazardous condition? Was it the work of some third party and the owner of the premises didn't know about the hazard, or it just happened, the liquid was spilled and your mother, God bless her, was the first person to come upon it. In that sort of case, as unfortunate as it is, no one would be responsible, I don't believe, for her injuries. So first you just want to go through how did the fall happen, what documentation may exist, did she keep a diary of her injuries? Maybe she has some medical records with her. If not, we can always obtain those. But just go through the timeline of the events, what led her to my office, and then make an evaluation on whether or not there's someone responsible for her injuries.
Yeah, a lot of times in these cases, and you know, Josh mentioned this earlier in the show, video is an appropriate way to gather information. Sometimes getting a lawyer quickly is important because you can secure video, you can send a letter of preservation, and you want to have that documentation because it helps kind of tell a picture or show a picture of what actually happened. A lot of times it becomes a he said, she said, and if you've got forensic evidence in the form of video, for example, it helps kind of identify really what took place and what happened there. And you know, these things are as simple as, you know, going to a gas station and somebody does not replace the cap on where the gas was and someone blows their knee out. Trust me, we've seen those cases. Right. Or circumstances where there's at a convenience store, a leaking refrigerator that's leaking water all over the floor and has been for 3 weeks, and nobody cleaned it up and somebody breaks a hip and has to have surgery. Those are things where those folks didn't do anything wrong except show up to the wrong place and they're in the wrong place at the wrong time. And so you need someone there to be able to help evaluate your case if you work into those circumstances. Hopefully you never do, but if you do, there are lawyers out there that can definitely help you.
Got about 3 minutes remaining, but one more question I wanted to get to. How long does it take for a case like this to process?
That's kind of an impossible question.
Right,
to answer.
sure.
But
yeah.
I would say that one where liability is not clear, where, as Josh mentioned, it's a he said type scenario. Those cases can take anywhere from 1 to 2 years.
Wow.
So that's a lengthy period of time. There is most of the time, a 2-year statute of limitations, which is a time period on which you need to bring that claim if you wish to preserve that claim. So they can range anywhere from 60, 90 days to 2 years. But the one thing you want to be concerned with is at the time that you make a claim or you settle it or you get some sort of monetary reward, if that plaintiff or that injured party is well or as close to well as they're going to get.
Right, yeah. We have right at 2 minutes remaining. Want to give both of you the opportunity for a final thought. And Josh Snable, if you would, you go first.
Thank you so much for having me.
Thank you.
Yeah, so really what I would just encourage everyone to do is it's always free to call and consult an attorney. Never costs you a dime. Just some quick pointers. If you are injured, as soon as you're able, document the injury. Pictures, witnesses, that can go a long way towards proving your claim.
Yeah, the other thing I'd say is there's a whole other side to these claims, whether it's a child that's bit by a dog, whether it is somebody who falls into a gas can that has been, or a gas cap that's been taken off, or some other injury. There's a whole other side of this, and that is the medical side. Seek appropriate medical care. We're not talking about going to enhance your medical bills. We're talking about documenting what those medical injuries are to the extent that you have injuries. Sometimes you may have a claim, but you have very limited damages, and ultimately that case doesn't ever get filed. Sometimes you have significant injuries because you have a knee injury, a hip surgery, a shoulder surgery, whatever related to a premises claim, and you need to make sure you get that medical care handled on the front end immediately so that you're in a position to be able to document what happened to you.
Great advice tonight, gentlemen.
Great job. Thanks for being on.
Thank you.
Did a good job.
Thank you so much. Thank you, as always, for joining us. We really appreciate you being with us here each and every Sunday evening. As we wrap things up, a reminder, the Facebook contest, all you have to do, go to the Facebook page, just search the term Hollis Wright. You'll find the firm there. Just like and follow the page, and then you'll see the graphic, the image there for the contest. Just share that, and you're entered to win, giving away 4 tickets, so 2 sets. Be sure to take advantage of that. We always appreciate you being with us. We'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.